Unconscionability addresses the issue of fairness in contractual relationships. It relates to the formation of contracts or specific terms thereof that are deemed unconscionable or unfair. The starting point is that ordinarily the courts will not inquire about the fairness of a contract and will not interfere with contractual agreements. The principle of freedom of contract is paramount. That is, the parties to a contract should be free to negotiate whatever terms they deem beneficial for them, without courts interfering and judging whether a fair bargain has been made. However, the doctrine of unconscionability permits contracts to be declared invalid if they are grossly unfair, oppressive, and one-sided. We can distinguish between two aspects or types of unconscionability. The first one is procedural unconscionability. This involves the process of contract formation. For example, it could be unfair to hide important terms in fine print, or to use confusing legal language. It could also refer to unequal bargaining power, pressure tactics by one party, or factors showing a lack of understanding about the contract terms by one of the parties. The second type is substantive unconscionability. This involves unfairness with relation to the actual substance of the contract terms. For instance, this could be about excessive price terms or otherwise overly harsh and one-sided contractual provisions. Normally, in order for a court to find unconscionability or unfairness, both procedural and substantive unconscionability need to be present. However, according to some courts, it may be enough for just one of these elements to be present to support the court's invalidation of a contract. An example of a case that stands for the latter approach is Universal Grading System Service versus eBay, decided by the United States District Court for the Eastern District of New York in 2009. The court stated that although a finding that a contract is unenforceable is generally predicated upon a finding that a contractual provision is both procedurally and substantively unconscionable under New York law, the substantive element alone may render a provision unenforceable. In terms of the facts, the plaintiffs allege that a clause in eBay's user agreement concerning forum selection, that is, which court would be responsible to hear a case should there be a dispute between eBay and its customers, was unfair and therefore unenforceable. The plaintiffs argued that they had no choice but to agree to it, as otherwise they couldn't have used eBay's sales platform. However, the court denied that there was either procedural or substantive unfairness. The court stressed that an agreement cannot be considered procedurally unconscionable or a contract of adhesion simply because it is a forum contract, that is, a standardized type of contract that applies to all customers. The court also noted that the plaintiffs could have chosen not to register to use eBay's services, meaning that they had an alternative to accepting the terms of the user agreement. The plaintiffs also alleged that the user agreement was substantively unconscionable because it was one-sided and benefited only eBay. They claimed that being forced to bring lawsuits at eBay's principal place of business was only beneficial for eBay and therefore abusive. Again, the court disagreed. The court stated that since the user agreement bound both eBay and its users to the forum selection clause, the clause was not one-sided. Further, the court held that the requirement that suits against eBay be brought at its place of business in Santa Clara County, California, was not substantively unconscious. It remarked that courts have recognized the valid business reasons underlying a company's choice of its principal place of business as the forum for dispute resolution with its customers, especially where the company's customers are located in numerous jurisdictions. Therefore, neither type of unconscionability was present and the user agreement remained valid. A different decision was reached in Jones v. Star Credit Corporation, decided by the New York Supreme Court in 1969. The plaintiff's husband and wife, who were welfare recipients, were visited at home by a salesman. The salesman convinced them to agree to buy a freezer unit for $1,439. However, the regular retail value of the unit was only about $300. Subsequently, the buyer started making down payments towards the full purchase price, but eventually it refused to make further payments. Litigation ensued, and the court had to decide whether, as the Joneses allege, the contract was unconscionable. The court analyzed the issue in the light of Section 2-302 of the Uniform Commercial Code, which applied to this type of contract. This section reads in part, "If the court, as a matter of law, finds the contract or any clause of the contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result." In assessing the fairness of the contract, the court looked at a number of factors. It examined the difference in value and price, the limited financial resources of the purchasers that were known to the seller, the value of allowing the buyers to pay in a number of installments, and the inequality of bargaining power between the parties. Based on these factors, the court held for the Joneses. It found that the contract had in fact been unconscionable, given the extreme difference between value and price, as well as the personal circumstances of the buyers and their lack of bargaining power. In terms of the remedy, the court decided that no further payments were due by the plaintiffs, as the seller had already received $600 towards the purchase of the $300 freezer unit. It was therefore the opinion of the court that the seller had already been amply compensated. The court therefore reformed the contract to amend the purchase price to $600.